morning, the US Supreme Court has ruled that Donald Trump has some immunity from prosecution for official actions taken while he was in the White House. The landmark decision is likely to delay his trial for interfering in the 2020 election. The former president described the decision as a big win. Our North America editor Sarah Smith reports.
The powerful Supreme Court has the final say on what presidents can and cannot do. Today's historic ruling means a president can never be prosecuted for anything that's part of their official duties, but they do not have immunity for non-official acts.
Hi guys, Adam is here. So what just happened? The Supreme Court handed Donald Trump the most expansive presidential immunity protection in American history. Absolute immunity for core functions. Presumptive immunity for official acts. It was supposed to be the shield that made him untouchable. And then, just as his team was celebrating, the same court turned around and told him something else entirely. Something that his entire governance model was built on assuming would never happen.
We want to begin tonight with that major news from the U.S. Supreme Court. The justices agreeing to consider whether Donald Trump must stand trial over charges he plotted to overturn the 2020 presidential election. The former president has claimed that he's entitled to absolute immunity because he was president at the time. Well, a lower court has rejected that. And today we learned that the highest court in the land, acknowledging the historic importance of this case, will hear arguments the week of April 22nd. That's a little less than 2 months from now. And this sets the stage for a landmark ruling on presidential power. And just to give you some context, that week that the court will hear these arguments, Donald Trump is expected to be sitting in a New York City courtroom for the criminal trial related to his alleged hush money payments to porn star Stormy Daniels.
They told him his most sweeping claim of authority, the one about tariffs, about emergency powers, about being able to bypass Congress whenever he wanted, exceeded his constitutional power. They told him that immunity from prosecution for official acts does not mean he has unlimited authority to take those acts. They told him the shield protects the person, but not the power claim itself.
The U.S. Supreme Court earlier today ruled that Donald Trump is entitled to some immunity from criminal prosecution for acts he took, official acts, when he was president, and now the lower courts must decide which acts are official, which are not, which means that Trump's January 6th case is unlikely to happen before November's election, if at all.
Presidents have to be given total immunity. They have to be allowed to do their job.
And the reaction? Total chaos. Live, on camera, Trump fuming, Trump lashing out at the justices, Trump attacking his own appointees, Trump insisting he still has ways to go around them. This is not the behavior of someone who understands the legal architecture he's operating under. This is the behavior of someone who just discovered that the thing he thought was a blank check actually has very specific terms and conditions written in the fine print.
Supreme Court ruling recognizing former President Donald Trump's immunity claim for official acts as president, though rejected it for unofficial acts. The majority opinion delivered by Chief Justice John Roberts states while the president is not above the law, that he may not be prosecuted for exercising his core constitutional powers, and he is entitled to at least presumptive prosecution for his official acts. Still, it states that Trump is asserting a far broader immunity than the limited one we have recognized. Now, in the dissent, Justice Sonia Sotomayor countering that it makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law.
Let me walk you through exactly what happened, why the gap between what Trump thought the immunity ruling meant and what it actually means is producing the most consequential legal collision of his presidency, and why the total chaos live framing is not hyperbole. It's the most accurate description available of what is happening right now. Here is the specific documented record of what the immunity ruling actually established. In Trump v. United States, decided in July of 2024, the Supreme Court held 6-3 that former presidents have absolute criminal immunity for core constitutional functions. Things like issuing pardons, directing the Justice Department, commanding the military in constitutional ways. Those are untouchable. No prosecution. Period. For other official acts, things within what the court called the outer perimeter of presidential duties, they have presumptive immunity. That means the presumption starts in their favor, but it can be overcome. And here's the part that Trump's team conveniently downplayed. The court explicitly rejected his claim to blanket immunity for everything. They made clear he has zero immunity for purely private or unofficial conduct, campaign behavior, private business dealings, communications through personal channels. Those are fully prosecutable. The ACLU and the Brennan Center immediately warned that the ruling was unfounded and dangerous. They said it invites presidents to commit crimes using official tools without realistic fear of prosecution. The New York Times said it enormously increases the power of the presidency at the very moment Trump is promising to weaponize the government against his enemies. All of that was true. All of that was alarming. But what everyone missed was the narrow, technical distinction that would later become the most important legal detail of the second term. The court did not address whether the official acts the immunity protects are themselves constitutionally authorized or legally valid. The immunity protects the actor from prosecution for taking the acts, but it does not validate the acts themselves as within the president's authority. That distinction, immunity from prosecution does not equal authorization to act, is the key to everything that came next. Trump's team took the immunity ruling and ran with it. They conflated those two separate findings into a single claim. Immunity from prosecution for official acts means courts cannot constrain the official acts for which the president is immune. They turned it into a governance theory of essentially unlimited official authority. The idea was that if you can't criminally prosecute a president for something, you also can't enjoin it, you can't block it, you can't second-guess it. The most coercive constraint is unavailable, so all lesser constraints must be unavailable too. That conflation became the foundation of everything they tried to do in the second term. Emergency powers, tariffs, freezing congressionally approved funding, dismantling agencies. The argument was always the same. The immunity ruling means the courts have almost no power to stop us. And then February of 2026 happened. The same court that had given Trump his immunity shield ruled 6-3 that he had overstepped his authority. The case involved an emergency law Trump had invoked to impose sweeping global tariffs. The administration argued that vague language in the statute gave the president essentially unlimited power to adjust tariffs based on national security considerations. Chief Justice Roberts, writing for the majority, specifically rejected that reading. He said it would encroach on Congress's constitutional role. Those words matter. Encroach on Congress's constitutional role. That is not a technical procedural ruling. That is a constitutional boundary drawing. The court was telling Trump that he cannot invent new authorities out of vague emergency language, that the immunity from prosecution he enjoys for official acts does not create the authority to take those acts in the first place, that the shield protects him from being charged for what he does, but it does not make what he does lawful if it falls outside his constitutional power. And the reaction was immediate. Reuters and the New York Times both documented Trump as fuming, lashing out at the justices, including his own appointees, insisting he still has ways to go around them, attacking them for lacking courage, calling the ruling deeply disappointing and terrible. This is the total chaos moment, because what just happened is a direct collision between what the immunity ruling seemed to promise, untouchability, and what the tariff ruling confirmed it did not deliver, unlimited authority to act. The court gave him a shield and then immediately told him that shield does not cover the specific power claims he was trying to use it to protect. Let me break down why this distinction between immunity from prosecution and authority to act is the single most important analytical frame for understanding what's happening. The immunity ruling established two separate legal findings that Trump's team collapsed into one. Finding 1, presidents are presumptively immune from criminal prosecution for official acts. They cannot be charged and tried for conduct within the scope of their official duties. Finding 2, the court did not address whether the official acts the immunity protects are themselves constitutionally authorized or legally valid. Those are two different things. The immunity protects the person. It says you cannot send this person to prison for doing something that falls within the outer perimeter of their official duties. But it does not say that everything within the outer perimeter of their official duties is something they are actually authorized to do. The scope of authority is a separate question. It always has been. Trump's team conflated those two findings into the claim that immunity from prosecution for official acts means courts cannot constrain the official acts for which the president is immune. That conflation produced the governance theory of essentially unlimited official authority. The argument was seductive because it had a superficial logical structure. If the strongest constraint, criminal prosecution, is unavailable, then weaker constraints like civil suits and injunctions should also be unavailable. But the logical structure fails because it conflates two completely separate legal questions. Criminal prosecution immunity addresses what happens to the actor after taking the act. Constitutional authority addresses whether the actor had the power to take the act in the first place. You can be immune from prosecution for something you had no authority to do. Those two facts can coexist. The Tariff ruling made that explicit. Roberts wrote that Trump could not invent new authorities out of vague emergency language regardless of his immunity from prosecution for exercising that authority. Immune from prosecution for taking the act. Not authorized to take the act in the first place. Two different things. This is the specific judicial clarification that demolished the conflation at the heart of Trump's governance model. And the total chaos we're seeing is the cognitive collision between a governance model built on that conflation and a judicial system that just said the conflation is legally invalid. Now let's talk about what this means for everything else, because the Tariff ruling is not an isolated event. It is the first major application of a principle that will now be applied across every authority claim premised on the same conflation. The major questions doctrine. The principle that when an agency claims to discover a vast new power in vague statutory language, courts will require clear congressional authorization, has been building for years. The Tariff ruling is its most dramatic application yet. And now that the court has established that immunity from prosecution does not authorize the act, every other initiative built on the same vague statutory foundations is vulnerable to the same challenge. Emergency powers. The freeze on congressionally approved funding, the mass firing of federal workers, the dismantling of agencies. The same argument that Trump's team has been making in every case, that the immunity ruling means courts have almost no power to stop them, has just been demolished by the court itself. The immunity shield protects the actor. It does not authorize the act. And if the act was never within the president's constitutional authority to take, the courts can and will enjoin it regardless of his immunity from prosecution for attempting it. This is the legal architecture of the second-term accountability story that most people are missing. Two rulings, one granting immunity, one constraining authority. Together they create the boundaries within which the governance model must operate. And those boundaries are much narrower than Trump's team assumed. The immunity ruling's rejection of blanket immunity is the most consequential finding for the criminal accountability picture. The court specifically rejected Trump's claim that presidents cannot be prosecuted for anything done while president unless first impeached, and it specifically established zero immunity for unofficial conduct, private communications, campaign activities, personal business dealings. That means the hush money conviction, built entirely on private business conduct and campaign activities, survives the immunity challenge. The unofficial conduct categories are fully prosecutable, and every other accountability case built around conduct that was private rather than official in character remains alive. The immunity to authority conflation that Trump's team deployed is the specific governance theory most completely demolished by the Tariff ruling. The conflation argument was that immunity from prosecution for official acts means courts have almost no power to second-guess official authority claims. The Tariff ruling establishes the exact opposite. Immunity from prosecution and authorization to act are legally distinct questions, each answered independently. A governance model built on conflating them is a governance model built on a legal error. And now that the error has been exposed in the Tariff context, it will be exposed in every other context where the same conflation was deployed. Trump fuming and lashing out at his own appointees is the most specific behavioral documentation of the total chaos. A general attack on the court would be standard political response. Attacking his own appointees, The justices whose appointments were the most celebrated achievement of his first term is something else entirely. It reveals the depth of the betrayal assumption that was violated. The assumption was that his appointees would never exercise independence against his interest, that the appointments were designed to produce the institutional loyalty his governance model required. The 6-3 majority, including 2 Trump nominees, most dramatically violated that assumption. And the attack is the behavioral expression of that violation, the most specific available documentation of the chaos produced by the gap between the governance model's assumption and the judicial reality. Here's what we need to watch as this story continues to develop. The hush money appellate proceedings will determine whether the immunity ruling's official act framework affects the 34-count conviction or whether the unofficial conduct finding keeps it intact. The classified documents and election interference cases will test whether the unofficial conduct zero immunity finding maintains the accountability exposure for the private campaign conduct those cases are built around. The Georgia RICO case, proceeding on its own state-level timeline, will test whether the federal immunity ruling provides any protection against state prosecution. And the major questions doctrine's cascading application will determine whether the tariff ruling's authority constraint gets applied consistently across every administration initiative built on the same vague statutory language. If it does, the immunity shield's most fundamental operational assumption, that official immunity equals official authority, will be comprehensively demolished across the full scope of the governance model simultaneously. Here's the bottom line on everything we covered. The Supreme Court gave Trump immunity from criminal prosecution for official acts, absolute immunity for core functions, presumptive immunity for other official acts, zero immunity for unofficial conduct. His team took that ruling and ran with it, arguing that it meant courts had almost no power to second-guess his official authority claims. They built an entire governance model on the conflation of 2 separate legal questions: immunity from prosecution and authorization to act. Then, the same court ruled 6-3 that Trump had overstepped his authority on tariffs. Roberts wrote that he could not invent new authorities out of vague emergency language regardless of his immunity from prosecution for exercising that authority. The ruling established that immunity from prosecution does not authorize the act, that the shield protects the person but not the power claim itself. The reaction was total chaos. Live, on camera, Trump fuming, lashing out at the justices, attacking his own appointees, insisting he still has ways to go around them. The behavioral expression of a governance model's most fundamental assumption being violated in real time. The immunity shield is real. It protects Trump from criminal prosecution for official acts within his constitutional authority. It does not protect power claims that were never within his constitutional authority to make, and the court that gave him the shield is now drawing the lines that most specifically establish where the authority ends, producing the total chaos that the gap between the untouchable assumption and the constitutional boundary reality most specifically describes. Stay tuned. The hush money appellate proceedings are active. The Georgia case is developing. The major questions doctrine is cascading. And we're going to be right here covering every single development as it unfolds.